Senator Pate.
Thank you, Madam Speaker. Honourable Senators, I speak as a member of the Indigenous Peoples Committee in support of these carefully considered and evidence-based amendments to eradicate sex and race-based discrimination perpetuated by Bill S-2. The amendments notably remove the second-generation cutoff, which Canada added to the Indian Act unilaterally and without consultation in 1985. Allowing this provision to stand means putting the legislative existence of First Nations at risk and allowing Canada to control and dictate who belongs and who does not, who is owed obligations by the Crown and who is not. Colleagues, we must not be party to continuing Indian Act discrimination that we know exists. Each day of inaction matters. First Nations women and their descendants continue to be disproportionately impacted, needlessly put at risk, their ties to family, culture, community, and land. First Nations governments have to stretch oversubscribed resources to support and include community members that Canada refuses to recognize. Experts, including the National Inquiry into Missing and Murdered Indigenous Women and Girls, warn us that we are perpetuating assimilation, colonialism, and genocide. Witnesses, including Dr. Pam Palmater, emphasize that this discrimination is the root cause of violence against women because it separates Indigenous women from communities of support. Witness Zoe Craig-Sparrow put the urgency in starkly personal terms. She is planning to have children while knowing the government will not recognize them as part of her people and nation. She said, and I quote, "You heard a lot about the second-generation cutoff. I am the cutoff." I speak today in support of our Indigenous colleagues whose leadership brought about these amendments and in support of Indigenous rights holders, individuals and nations who have lived the harm and injustice of the second-generation cutoff and overwhelmingly told the committee and are telling this chamber no more. I also speak as a senator who began attending the Indigenous Peoples Committee in 2016, shortly after my appointment, during the study of Bill S-3. That bill, like Bill S-2, forms part of a 40-year history of government legislation that has introduced incremental steps in response to legal action by First Nations women and their descendants and now proposes to continue discrimination. I have spent 9 years in the Senate hearing promises from the government that they take ending discrimination in the Indian Act seriously and will deal with this issue soon, but never now. Sharon McIver has spent her entire life advocating equality for herself and countless others. She has heard the same promises from 18 different ministers as piece after piece of inadequate legislation worked its way through Parliament and then court challenges. The government advocates further consultations. With respect, we need not make an either-or choice between consulting and amending. Through these amendments, Canada can meet its immediate charter obligations to eliminate the discrimination now, while also continuing on how to implement the changes in a way that advances and supports self-determination. These amendments before us were advocated by witnesses representing the majority of First Nations and First Nations organizations taking part in the government's current consultation process. They told committee that these amendments were an urgently needed solution. While Canada must uphold its duty to consult, it cannot consult about whether or not to discriminate based on race or sex, whether or not to maintain a legislative extinction formula, and whether or not to contribute to an act of genocide. Canada can, however, uphold its constitutional obligation to end the discrimination and then consult about how to support communities. We are urged to abandon the amendments because this time the promise to end discrimination is being made by the first Indigenous minister responsible for the department. The amendments are not about doubting the integrity, intentions, or goodwill of the current minister. And you've heard that now from a number of us. We have seen that sincerity in other similarly situated ministers, however. Many of you will remember a commitment to implement an adequate Canada disability benefit by the first minister responsible for disabilities, who lived with disability herself. The Senate saw a lack of specific commitments in the text of Bill C-22, but passed the legislation because we trusted her integrity, her honesty, her willingness, and her commitment to follow through. The minister was subsequently moved out of her portfolio, and an inadequate Canada disability benefit was introduced. Nor can we forget Bill C-5, where no consultations occurred because the same government asking First Nations to trust it to uphold their rights with respect to Bill S-2 concluded, quote, Bill C-5 doesn't directly concern the rights of Indigenous communities, end quote. First Nations disagree. At least 9 First Nations here in Ontario have sued the government alleging charter breaches in Bill C-5 and noting the law, quote, necessarily diminishes the ability of First Nations to engage, end quote. Just last week, Bill C-5 was referenced in a memorandum of understanding for a pipeline through territory of coastal First Nations in BC, who state they were not consulted. Why are decisions to exploit First Nations land being rammed through without consultation by the same government that says 40 years of consultation is an inadequate basis for ending discrimination against First Nations women and children? Bill S-2 itself was initially introduced in a different parliament by a different minister. The current minister's consultation process was not followed with respect to at least some of the bill's provisions. At committee, Alison Bear, General Legal Counsel for the Whitecap Dakota Nation, spoke about clauses 10 and 11 of Bill S-2, which proposes a bar to compensation, and I quote, "No one has given consent to put in a clause that says we are not able to practice our rights and sue regarding something that discriminates against all of us. None of our nations have agreed to or even been made aware of that clause within Bill S-2, and it definitely needs to be struck from the bill," end quote. The report before you includes a deletion of these 2 clauses. We have heard the government is concerned about the amendments being challenged in court. Not only was the likelihood of litigation from First Nations not a barrier to the government fast-tracking Bill C-5, it is not clear who, other than the government itself, might push to reinstate the bar to compensation or the second-generation cutoff. By contrast, the committee heard that if the bill is not amended, at least one group is virtually certain to mount a charter challenge in response. Constitutional lawyer Mary Eberts, who has been involved in litigating sex discrimination in the Indian Act since the 1980s, testified, quote, "I think that if Bill S-2 passes the way it is now, there will be litigation within 6 weeks to 2 months about challenging the second-generation cutoff and the ban on recovery of damages. That's a prediction that is almost a promise," end quote. The government states that we should wait for a standalone bill because the minister will, quote, "complete the consultation process in the next weeks," end quote. As Senator Ringett rightly pointed out, if consultations are complete in a matter of weeks, that would be ideal time to proceed with amendments that allow the House of Commons to consider them alongside the outcomes of the consultation ahead of April's court deadline relating to Bill S-2. It is disingenuous and unacceptable for Canada to once again tell Indigenous peoples to wait for equality that has been guaranteed in the Charter for 40 years. Through 4 decades of consultations on discrimination in the Indian Act, First Nations people have told Canada that removing the second-generation cutoff and bars to compensation for discrimination are urgent priorities. The Indigenous Peoples Committee 2022 report, entitled Make It Stop, supported and amplified First Nations calls for urgent action. Bill S-2 was not a proactive step by the government in response to those consultations and recommendations. It sits alongside at least 4 other pieces of legislation only introduced because the government was forced by a court to act. Each time, instead of bringing forward legislation to ensure equality for all, the government has chosen to do the bare minimum, proposing incremental legislation that forces First Nations people, especially women and their descendants, back to court to uphold their rights under a legislative regime containing bars to compensation. This is an approach that utterly fails to eradicate inequality. Worse yet, such political maneuvers perpetuate discrimination. The Deschanel case that gave rise to Bill S-3 in 2017 called out the government, noting that Parliament can and must take steps to, quote, identify and settle all other discriminatory situations, whether they are based on sex or on other prohibited grounds, in accordance with its constitutional obligation to ensure that the laws respect the rights enshrined in the Canadian Charter, end quote. As the Supreme Court of Canada also noted in the Vreen decision, quote, groups that have historically been the target of discrimination cannot be expected to wait patiently for the protection of their human dignity and equal rights while governments move toward reform one step at a time, end quote. Without a legislative commitment to end the second-generation cutoff, the question of whether discrimination will end remains uncertain. As Rose LeMay summarized in the Hill Times recently, it's, quote, it's like demanding to spend a few $1 million consulting people who are hungry and asking, do you want food in a year or 5 years, instead of feeding them, end quote. The amendments before us today can and should operate alongside a consultation process. The amendments could ensure that Canada is not consulting on whether to end discrimination. The consultation process would focus on how to support communities in welcoming back those who Canada tried to forcibly remove, how to support those newly registered, how to ensure access to housing and infrastructure for all. Together, we can support the intentions and the positive steps of the Minister to undertake consultations while also upholding Canada's constitutional duties to eradicate discrimination against the so-called minority groups this place has a special duty to represent. This, to me, is clearly one of those moments where we must stand in support of those groups. Rather than rubber stamp a constitutionally inadequate response that perpetuates a shameful colonial history, we must support First Nations and send a clear message that we no longer facilitate ongoing discrimination. Miigwech, merci, thank you.